All right, future CPAs, listen up. We're diving straight into the law on sales. And look, this isn't just about acing your next quiz. We're thinking long-term here, like board exam level long-term. Today, we're going to crack the code on two massive questions. Who can actually, legally, make a deal? And when, like down to the very second, does that deal become official?
So, here's our game plan. First, we'll figure out who can even be a player in a sales contract. Then, we'll hit the prohibited list, the absolute no-go zone. After that, we'll pinpoint that magic moment a sale becomes official. We'll also get into the whole handshake versus paperwork debate, and then we'll wrap it all up with a rapid-fire review to really hammer it home.
You know what I know, the real win isn't just passing quiz 3. It's about getting this stuff so deep in your brain that it's still there, sharp and ready, when you're sitting for the LECPA in a few years. Cramming just won't cut it. So this whole explainer is built to help you build those mental connections so this information sticks for good.
Okay, let's build from the ground up. Before any money changes hands, before any property moves, we have to answer the most basic question. Who is even allowed at the table? This all boils down to one core legal idea: capacity.
So, Article 1489 starts us off nice and easy. The general rule is basically this: if you are a person who can legally bind yourself to a promise, you're good to go. You have the legal capacity to enter into a contract of sale. But you know how this works. The really tricky questions, the ones they love for the exams, are always hiding in the exceptions.
And here's the first major split you absolutely have to understand. We have two types of exceptions. First, there's absolute incapacity. Think of it this way. The person themselves is the issue. They can't give valid consent to any contract. Then you've got relative incapacity. Here, the person is perfectly capable, but the specific situation makes the sale a no-go. It's not about the person, it's about the context.
So who's on this absolute incapacity list? The law points to 3 groups: minors, insane or demented persons, and deaf mutes who don't know how to write. Now here's the money shot, the part you need to highlight in your notes. If you make a contract with one of these people, it's not automatically void, it's voidable. That means the contract is actually considered valid until a court steps in and officially cancels it. Big difference.
Now for a classic exam twist. What if a minor sells something to another minor? When you've got absolute incapacity on both sides of the deal, the status changes. The contract is no longer just voidable, it becomes unenforceable. That means no one can drag the other person to court to make them follow through. It's a legal dead end. That distinction is pure exam gold.
Okay, let's pivot to relative incapacity. Remember, these are people who are generally fine to make contracts, but the law puts up a big stop sign for certain sales. The whole point is to shut down potential fraud and abuse of power.
And the first big one on this list is the spousal rule from Article 1490. As a general rule, a husband and wife can't sell property to one another. Why? Well, the law is trying to prevent a couple of things, like faking a sale to hide assets from people they owe money to, or one spouse pressuring the other into a bad deal.
But of course, there are exceptions. There are 2 big ones you need to know. A sale between spouses is totally fine if they agreed to a separation of property in their prenup. It's also allowed if a court has officially ordered their properties to be separated. In those cases, it's game on.
And here it is, the big list from Article 1491. You've got to commit this to memory. Here's a study hack. Just think GAEPJ. That's guardians, agents, executors, public officers, and judicial officers like judges and lawyers. Each one is barred from buying property that's connected to their professional duties. It's a no-brainer, really. It's all about preventing a massive conflict of interest.
So we've nailed down the who. Now let's tackle the when. What is the exact precise moment that an agreement flips a switch and becomes a real, legally binding contract? This moment has a name: the point of perfection.
Article 1475 gives us the answer, and it's beautiful in its simplicity. A contract of sale is perfected by consent alone. The second there is a meeting of the minds on 2 and only 2 things, the specific object and the price, boom, it's done. You have a perfected contract. From that instant forward, the parties can legally demand performance from each other. Let's make this real with an auction. It's the perfect example. So each item or lot is its own separate sale. When people shout out prices, those are just offers. A bidder can even change their mind and take it back. But then it happens. The fall of the hammer. That's the moment of perfection.
The deal is sealed, the contract is made. It's that clear.
Okay, so we know a sale is perfected just by agreement. But does that mean a verbal deal, a simple handshake, is always enough to win in court? Well, not exactly. This is where we need to talk about the Statute of Frauds.
So, let's ask the question directly. Can you always rely on a spoken agreement? You see, a contract can be totally valid, meaning it exists legally, but being enforceable, meaning you can actually get a court to back you up, that's a whole different story. So the answer is, usually, yes, an oral contract is valid. But, and this is a huge but, the law has this thing called the Statute of Frauds. You can think of it like a bouncer at a club. For certain types of sales, if you don't have written proof, the court won't even let you in the door to argue your case.
And here are the three big ones that need a paper trail to be enforceable. Number 1, selling personal property like a phone or a laptop for 500 pesos or more. Number 2, the sale of any real property. Doesn't matter the price. A piece of land, gotta be in writing. And number 3, any sale that, by its terms, isn't going to be finished within a year. For these 3, no writing, no enforcement, period.
Okay, that was a lot, but we're going to tie it all together and lock it in your memory right now with a high-speed review. This is the stuff you absolutely positively have to know. Ready?
Let's hit the highlights. Capacity. Know the difference between absolute incapacity, which makes a contract voidable, and relative incapacity, which just prohibits certain sales. The prohibited list. Don't forget our mnemonic, GAEPJ. Spouses. Can't sell to each other without that separation of property agreement. Perfection. It's all about the meeting of minds on the object and price. And finally, the Statute of Frauds. Remember, you need writing for real property, personal property worth 500 pesos or more, and deals that take over a year.
All right, let's leave you with a quick brain teaser to make sure this sticks. Imagine your boss is a judge. She just finished a big case involving a piece of land. A week later, she pulls you aside and asks you to help her buy that exact same property. What rules should be screaming in your head right now? What's the massive red flag? If you're thinking Article 1491, relative incapacity, you've got it. Applying these rules to real situations, that's how you'll own this stuff on exam day. You got this.